for startup. Push yourself because no one is going to do it for you. Now, I like to welcome Dr. P. Parvadam Ma'am, Associate Professor, Department of Corporate Secretaryship with CA and Professional Accounting, to present a welcome address.
Good afternoon, honorable present here. On behalf of Institution Innovation Cell, Congards and Science College, Autonomous, Erode, a warm welcome to every present here. First, my gracious welcome to our honorable correspondent, Thiru K. Palanisamy Avargal, for his constant encouragement on innovative programs. I welcome you, sir. My cordial welcome to our respected principal, Dr. N. Raman, for his moral support and motivation. I welcome you, sir. Then my cheerful welcome to our esteemed chief guest, Ms. Kavita Karthikeyan, Associate Professor and Head, Quality Assurance Cell, Innovation Ambassador, Institutions Innovation Council, Prince Sri Venkateshwara Padmavati Engineering College, Ponmar, Chennai, who are sharing their precious time to render their talk. I welcome you, ma'am. Next, I special welcome to our IAC President, Dr. Gayatri, Associate Professor, Department of PG Computer Science, and I welcome Vice President of IAC, Dr. VG Sumadi, Department of Management Studies, who are the conveyor of the program. I am happy to welcome heads of various departments and faculty members of Congards and Science College. And I also welcome IAC department coordinators and students representatives to this program. Last but not least, I welcome all the students of Congards and Science College. Once again, I welcome you all.
Thank you, ma'am. The expert in anything was once a beginner. It's my pleasure to welcome Dr. VJ Sumati ma'am, Head and Associate Professor, Department of Management Science, to give a chief guest introduction.
Good afternoon all. Professor Kavita Karthikeyan is a civil engineering professional with her credential of first class with distinction in BE and University Gold Medalist in her MTech degree. She is currently doing her innovative idea as thesis in VIT University Chennai campus. With 18 years of experience in teaching and research, she has served in well-reputed organizations like DHA and Foundations Madurai, VIT University Vellore, IIT Chennai, and currently she is serving at Prince Sri Venkateshwara Padmavati Engineering College, Chennai. She has received AICT's Leelavati Award 21-22 for Women Empowerment on 8 March 2022 at New Delhi and was announced as first runner under the theme Technology for Women. And she is also a member of various professional bodies such as ISTE, Indian Association of Hydrologists, Indian Water Resource Society, etc. Here are some of her academic achievements. She has received up to 10 lakhs from various funding agencies for research and development projects and seminars. She has visited 2 countries and she has also participated in nearly 12 international conferences and workshops in which she has presented a paper titled Agriculture Disease Mitigation and Advisory System at University College, London. She has 11 international and national publications, 4 patents with her, organized 58 seminars, conferences, workshops, and also attended 62 seminars, conferences, workshops, and trainings. She has been invited as a speaker for nearly 42 institutions, and she has authored a book entitled Environment and Agriculture. Mrs. Kavita Karthikeyan has a strong passion for innovations and she has been involved in motivating students and faculties towards smart work, leadership skills, creative thinking, entrepreneurship, etc. She is also an entrepreneur managing a startup in financial services. So we are glad to have the multi-faced personality with us today. Ma'am, now the floor is yours.
Yeah, thank you, ma'am. Thank you so much, and a warm afternoon to all of you from Congo Arts and Science College. It's been a privilege to be here among the young minds and young faculty, talented faculty of Congo Arts and Science College. First of all, I'd like to thank our Institutions Innovation Council from our MHRD for giving us this opportunity to interact on IPR innovations all over the about the theme with all the students and faculty. So thanks to Institutions Innovation Council. Next, I would like to thank Congo Arts and Science College management, the principal Dr. N. Raman, and correspondent Thiru K. Palanisamy, and the IIC president Dr. J. Gayatri, and all other team members of IIC from Congo Arts and Science College for having me here for this wonderful session. And a warm welcome to all the students and faculty from Congo Arts and Science College. It's been a very great platform for me to meet you today over this Zoom, because it is impossible to, not so impossible, but a little, it's a time consuming thing to come over to E-Road and meet you all in person. But this platform is creating us and giving us an opportunity to interact online and also interact with people who are having similar thoughts and related to IPR and innovations and entrepreneurship. So though it is a mandatory session that IIC wants, but the take home from this session would be great. And if at least a few or 5 to 10% of the people are able to take something, take a lesson that I am going to ideate, I'm going to innovate, I'm going to get my patent file, then that is the great success of this program. Because young students of now are going to be the innovators, are going to be the entrepreneurs for the future. And the future of India is the young minds. Now they are in the colleges. So at the government level, the policies and the government and our Prime Minister, Honorable Prime Minister, all are working towards motivating young minds and faculty towards ideation, innovations, taking the patents and starting a business and so starting a startup and so on. So because the need of the hour is entrepreneurship. Ultimately, what India wants is make in India. So make in India is something which we have the products, we produce it, and we generate employment for most of the people, because ideas from here are moving to the other countries, and it has been patented in other countries, and the business are flourishing in other countries. But that has to be brought to an end. So that is the entire scenario of creating a different strategy of tapping the entire potential of all the ideas in India itself. So this innovation and entrepreneurial ecosystem is going to help the future generation of India to ideate, innovate, and start their own business. They are going to be the entrepreneurs and also make India proud, so that India is getting more ranks in the at the global level in case of innovation and entrepreneurship. So with this note, I would like to move into the actual session. I'll share my screen. Is my screen visible?
Yes, ma'am.
Okay. So today we are here. I think almost most of you would have known about ideation, creative thinking, design thinking, how to innovate, and all those things, as previously IIC would have handled or brought in experts for that sessions. So here we are here today. We are here to see what is an intellectual property and what is the intellectual property rights, and how a startup or a person who is going to start his own business maybe in another few months is going to manage the IP and the IPR in his business. So that is what we are going to see through this session. It'll not be more of technical things, but I'll tell you what is IP, what is IPR, how we are going to face it, how one startup person is going to face that, and what are all the procedures to follow on that. So few years, that is maybe in a year, decade before, if you would have heard about the people talking about IP, IPR, they would have said it is a very tough process. We cannot go single-handed in that. It is a long process. It takes time, and it is not easy to get an IPR. So that was I had heard it, because in 2008 when I was working in Vellore TBI, they say that getting an IP is something which is like seeing the kurunji flower for like in 12 years. So that was the trend. But now it is very easy for any common man to get his ideas patented and also start a business within a year or even within 6 months. So that is what the technology and the government is bringing to us, and it is giving to us to develop more innovations and go into the entrepreneurial ecosystem. So that is what the trend is here, and sure this session will help you in also addressing those issues and will help you in guiding what are the steps for an IP management for a startup. And at this point I would like to thank our IIC, because every training session which IIC provided for an innovation ambassador was a worthy and valuable session, because I learned a lot of things from the training sessions. And my inspiration for this IPR, knowing about IPR and how to manage things in IPR, came from particularly this session which was handled by Dr. Sanjeeva Kumar Majumdar, Generation and Management of IP at the Early Stage of Innovation and Startup Development. So this was my eye-opening session. I attended this session online, but frankly to say, I got interest into IPR and I started moving towards creating my own IPR login ID and then applying for patents. I myself apply for patents. I do it for others also. So this is the session which helped me a lot, and thanks to IIC and thanks to the professor, for Dr. Sanjeeva Kumar Majumdar, for giving me this opportunity and the enlightening session through IIC. That is a very important thing. And most of my topics also, like the explanations, would be taken from sir's videos. So I'm very glad and I acknowledge him on this platform, so that it also helped me. It is going to help most of them in the future. So thank you IIC and sir for that. And now every thing starts with a question. So students are there here. I would like students to interact, so that we can make this afternoon a very happy afternoon, and also a very interactive afternoon, because afternoons are always boring, right? So we need not will not happen that now. So I want answer for this question. Any idea on what is India's rank in the International Intellectual Property Index? Students? And I would like to say young minds who are very technical savvy, technology savvy, very fast in operating all the devices, and even intellectual than the faculty members. I want answers from students. Please, even if it is wrong, not a problem. We are there to help you. You can attempt the answer. Anybody?
43.
43. Very good. Very good. 43. Close. Out of
55.
55. No, okay. The rank is got out of 55 countries, global countries. You mean to say that? What's your name, ma? Saubarnika. Janardhani. Okay. So Janardhani has answered that 40. India is ranked in the 43rd rank out of 55 countries. That was the that is the rank. Any other answer? Anybody? By now you could have also Google searched, because it comes first when you search what is India's rank in Intellectual Property Index.
55.
55th rank, you mean? $55th rank, is it? Okay, so 43, 55. Now let's see what is the answer. So India is ranked 40th for the year 2020, and we have scored 38.4 marks, 38.4 marks out of 100 in a set of 50 intellectual property related indicators. Out of the 53 global countries, global economies, India is being ranked 40th. So where are we standing? Out of the 53, we are in the 40th place in intellectual property rights. So is this rank a good one, or we could improve, or what can be the solution? Any one of you, or we'll maintain the same thing? Is it okay for us to stay in the same rank?
No, ma'am, we should improve, ma'am.
Yes, very good. We should improve. So what can be the strategy to improve this rank? Yes. What will be the strategy? If we are one of the given as one of the highest position in our country, what will be our strategy to address this? Imagine, like, if I am the PM, Prime Minister, so what will I do? Please answer. What strategy can we take? Guys? Okay, so what will be the strategy? Anyone, not so is the question so difficult to answer? Kashthama irukkuda? Are you able to hear me? Hello?
Yes, ma'am.
Yes, okay. No response, so I thought I'm offline. Okay, so if this is the rank in 2020, and now we have to think on how to improve this. So that is what the IIC and the government is trying to do. Okay, so that is the first step that IIC, or the major step that IIC and the government is trying to bring in lots of innovations, bring in lots of patents, and finally bring into the entrepreneurial community. So that is where we are standing, and maybe in another 5 years we might go to the top 20 into top 20. Okay, so we'll be in the top 20 if we again show our interest in innovations and IPR. So that is the position. Now, going on, general knowledge is over. Now coming into the subject, how to for all the IPR or whatever we are going to talk in another 1 hour, the first thing is we have to be innovative. So to be innovative, what can be done? So how can we be innovative, or what is innovativeness? If we see, we can say that vision of seeing the invisible opportunities is said to be called as innovativeness. The vision of seeing invisible opportunities is said to be called as innovativeness. And the innovative person should have, the entrepreneur, the person who is innovative, there are possibilities of making him as an entrepreneur. The person have a mission of solving the impossible thing. So that is the attitude of an entrepreneur. So innovative persons can see the invisible opportunities, and the opportunities will be taken up by an entrepreneur, and it will be solved for the best thing. So that is the attitude and the knowledge and the skill of an entrepreneur. So to be innovative, we have to explore new technologies, we have to reinvent new things, do something, recreate something which is in an older way, you make it into a new trendy way, or experiment new things which will help in getting new exciting ideas, and you will gain lots of new skills. So being innovative is almost free to all. Anyone can be innovative, anybody can create things, anybody can ideate, and anybody can go for applying for patents of their ideas. So innovativeness is one skill set which is needed among the young students, so that the patenting process can be useful for the innovative ideas, right? So now coming to the assets, a short quiz, like what is tangible and what is an intangible asset? Answer.
Tangible is one which we can feel, touch.
Yes, very good.
Intangible is we cannot feel, ma'am.
Yes,
It's for example, copyrights, patent.
very good, very good. Exactly. So thank you. I think it is Saubarnika who answered this question. So tangible asset is something which we can feel and touch, monetary, mostly monetary, and intangible is something only we can have it as a satisfaction or a goodwill or something in paper or what the brain, the idea or all those things are said to be the knowledge we have, that is said to be called as the intangible assets. So if we see here the laptop, the gold and the money and the car and those three things are said to be called as intangible assets, and intangible is the brand and the software which we have developed in terms of the programming is said to be called as an intangible asset. So for tangible assets we have the rights of registering it, and we could own it, but how to protect our knowledge, how to protect the thing which we discover or with the thing which we innovate, or how to protect the thing which we invent. So that was again how to protect our knowledge was the basic idea from wherein the IP started, intellectual property rights started. So intangible assets, to protect our intangible assets, that is our knowledge or goodwill or the brand which we establish and the logo or the trademark or whatever we establish for a company, how to protect that. So that is going to be the way for the IPR. So again, this is again the definitions. Tangible assets, it can be equipment, machinery, buildings, vehicles, stock, land, and cash. You can touch it and you can see the monetary benefits. Intangible assets is trademarks, franchise, copyrights, license, goodwill, patents, brands. You can't touch it, but you can have it proudly as a satisfactory tool. So that is intangible assets. So these intangible assets have to be safeguarded, and for that we have the intellectual property. These intangible assets are called as intellectual property. So intangible assets, they have to be protected. The intangible assets have to be protected. If not protected, it will be easily taken away by other people, and it can be they might misuse it, and they might register a patent for it, and they might use it for their business. So the intangible asset, our knowledge, our ideas, our innovations, our inventions, all those have to be uh, uh, safeguarded through the intellectual property rights. So intellectual property is an intangible creation of the human mind, usually expressed or translated into a tangible form. We are expressing, we are writing the idea, we are putting it in a paper, and we are filing it, and we are claiming the rights of the property. So that is what intellectual property means. Okay, so IP, all IP, intellectual property that we have should be protected. If not protected, then we are not going to be the owners. We cannot claim that we are the owners of the IP. So that is intellectual property rights. And IP as a property, it is also a property like other properties, like the house or the car or the laptop, like other properties. IP, intellectual property, that is the idea or the patent or the business concept which we have patented, it can be sold. If I have an idea now, tomorrow or maybe after 6 months I don't want it, I'm not able to continue the business, I'm not able to take up the entire trade, and I'm going to sell it to someone else, I can do that. And other people, the property IP can be again bought. So I can sell one, I can sell my thing, I can also buy another IP, so it is on the other side. It can be given on lease, it can be also given for rent, so that is also possible. It can be assigned, I can assign I can assign or to a person or a company to see my IP and establish the business for the future also. And it can be passed under a will, like writing a will. I can pass my idea, my innovations, my startup, my company to my son or to my family members. I can write a will and I can pass it on to them. So IP, similarly, like all other properties, IP is also property which can be sold, which can be bought, which can be given for lease or rent. It can be assigned to someone else, and it can also be passed under a will. So that is all possible for an intellectual property. So now what is intellectual property rights? If we see, these are the rights which are acquired by the owner of an intellectual property. When I say intellectual property, it is the knowledge, it is the idea, it is the innovation. When I say intellectual property rights, it is the right which I am acquiring on my knowledge, on my idea, and my innovation. So intellectual property rights is the right I am getting, I am acquiring by filing the patent, and I am getting the right for my intellectual property, which can be the idea or the design or the logo or whatever it is. So IPR is the right which a person is acquiring for the intellectual property. So intellectual property is a category of property that includes intangible creation of the human intellect, and the creation of mind can be inventions. It can be a new thing, you can invent something and you can get the patent. Literary or artistic works, any book or any music or any themes or something, which is any design, any symbol, any logo, anything which is new that does not exist in the previous one. Names and images, which those also can be patented, and the property can IPR can be claimed for that. So the main purpose of the intellectual property law is to encourage the creation of a wide variety of intellectual goods. So this IPR encourages most of the innovators to come up with new ideas and patent it for the nation, for the improvement of the nation, as well as and for the improvement of the personnel itself. So because if an innovative idea is there, you can easily patent it now and you can start a business within a short span. So that is another one main purpose of the intellectual property law, and strike the right balance between the interest of innovators and wider public interest. So only if your idea is patented and you start a business, then the business is seen as a very potential business by the public people as well as by the government. If not patented, anybody can replicate it and anybody can take it as their business and they can establish the entire system. So the need for IPR is it encourages innovation, it increases the economical growth, safeguards the right of creation, ensures ease of doing business, and facilitates the transfer of technology. So transfer of technology here means if I'm just inventing or innovating an idea, I just innovate the idea, but I am not ready to do the business with that idea, but I can give the technology to someone else who is ready to take it as a business and do it as an startup. So I can transfer the technology, but I can transfer my idea through the patented idea to some other person so that I get the royalty, but the business is being run by some other person. So here again, I am transferring the technology. So all these are possible. And if we see that all these are going to economically build the person as well as build the nation. So ultimate goal is like building the nation and building a good entrepreneurial ecosystem in the nation. So that is what the need of IPR is. And for any business or for any startup, why IP is needed? So why IP protection is needed? As I said, only if your idea or innovation has been patented, you can get capitals or you can get funds from the venture capitalists or from the government or whatever scheme if you can avail. So if not patented, if just like that you're going to start the business without a patent and without any rights, then it can be easily taken up by the other people, it can be stealed and it can be used. So first thing startup needs is he should have patented his idea. So that is what will attract the funding people. Funding people will see only if the idea has been patented. Then you can, if your idea or if your business or your product is not patented, it cannot be marketed, it cannot be given advertisements, because when you without a patent, when you are marketing it, when you are advertising it, it is easy for your competitors to copy you and also take back all the formulas that you are using in your product. So that is again a problem. And no freeloaders. You cannot do anything in case you cannot tell it to any idea. You cannot tell it to anyone freely without a patent. And for improving the research and development, also the patent IP protection is needed, and to make profits the patent is needed, and to maintain loyal followers. Only if your product is patented, you can maintain the followers and the competitors. So for any business, the IP is very, very important. Protecting your idea is very, very important. Shall we start, ma'am?
Yes, ma'am.
Okay. So as I said, IP is needed for capital expenditure for new products like marketing and advertisements. Then no freeloaders to improve the research and development, and to get more increase in the number of products and the service, we need an IP. And to make more profits and maintain loyal followers, also a startup needs an intellectual property protection. So that is the need for the IPR. And now coming into the IPR in India. So what are all the intellectual property rights available in India? So that is what, according to our government, the details are being presented here. Here it is like we can get intellectual property rights. So the different types of property rights are patents, trademark, copyright, plant breeders' right, utility or model design, and geographical indication and trade secrets. So these are the types of IPR available in India for us to get the intellectual property rights and the legal rights of our ideas and knowledges. So patent, if we see, it is a granted for invention, which is a new product or a process. It can be for a product, it can be for a process. So the patent is the is granted for invention, which is a new product or process. So the law which is going to guide the Patent Act is Patent Act 1970, amended in 2006, and it has been formulated by the Ministry of Commerce and Industry of Government of India. And if we take a patent for a grant, patent grant for now if we take a patent grant, we are the owner for it for 20 years. It is given for 20 years. So after 20 years, we cannot claim it, but till 20 years we will be the owner for the invention, that is the patent, once it is granted. And after 20 years it cannot be renewed. So it cannot be renewed at all. So we have to claim that only for 20 years. And then the second type is a trademark. So trademark is typically a name, a word, a phrase, a logo, symbol, design, image, or a combination of these elements. Like the logo, the image, or the photo, on all those things can be filed as a trademark. And the act which is linked with trademark is Trademark Act 1999. And again, Ministry of Commerce and Industry will be taking care of this. And the trademark is valid for a period of 10 years, and it can be renewed. So trademark can be renewed for 10 years. After 10 years, you can renew it and have it for 5 years again. So that is what it can be renewed for 10 years. So trademark is something which you create, a logo, a symbol which you create for your institution or for your product, and all those things can be patented as a trademark. So that is the second type. And next we have the copyright. Copyright is the bundle of rights given by the law to the creators of literary, dramatic, musical, and artistic works, and the producers of cinematograph, films, and sound recordings. So all that has been like cultural things. You can imagine like a script or a story or a song or a music or something which is filmed, that is, and the recordings and some music kind of thing. All those things can be claimed under copyright. You can take the ownership as copyright. And the act is Copyrights Act 1957, which is amended 2012. And we have the MHRD, the Copyright Office, MHRD, Ministry of Human Resource Development, taking care of this this particular copyright ownerships, and it is valid for a period of 60 years. So whatever you write, whatever you make it as a music or some artistic works, paintings or some drawings and all those, if you want to claim a copyright, then you can have it for 60 years. So that is copyright. And a plant variety protection, this is exclusively for the agricultural developments. So it refers to developing protecting a plant variety. So we can see that lots of plant varieties have been going out of existence. So protecting the plant variety, and these rights are given to the farmers and plant breeders, so they can go for crossbreeding and create a new variety of plant, and all those things can be patented under the plant variety protection. The law here is the Protection of Plant Varieties and Farmers' Rights Act 2001, and the department who is taking care of this is the Ministry of Agriculture department is taking care of this. And the period of protection for field crops is 15 years. For trees and vines, it is 18 years. So for crops which has been in the field, it is for 15 years. The plant variety protection patent is for 15 years, and that for the trees and the vines it is 18 years. So that is regarding the agricultural sector. And next we have the designs. So designs in the sense you have a 3D model, you have a 3D shape or a prototype you have done, and it is like a machine kind of thing or an equipment kind of thing. You can design that and you can also claim it for a patent. These are called as specifically industrial designs, which is in a 3D, which is having a 3-dimensional shape, and it is an article kind of thing. You can show it and you create it, you make a prototype and you claim for a design patent. It is exclusively called as an industrial design patent. So the law is Designs Act 2000, and again here Ministry of Commerce and Industry is taking care of this. And the period is, it is registered for 10 years, and after which it can be extended for 5 years. That is, it can be renewed for next 5 years. So that is by submitting the application of renewal. So that is the industry design patents, and that is the other type. And next type is the geographical indication. So geographical indication in the sense, it is like geography in the sense the area from where the product is being marketed, or from where the product is being produced. So we are going to use a geographical indication on that, like in say Kanjipuram saris, silk saris, all those things from a region. If the name is given to the product, then it is said to be called as geographical indication. So geographical indication is a sign used on products that have a specific geographical origin. The product should have originated from that place, that location, and possess qualities or a reputation that are due to that origin. So the law regarding the geographical indication is Geographical Indication of Goods Registration and Protection Act. Again, Ministry of Commerce and Industry is taking care of this, and this is again valid for 10 years, after which you will have to again claim for the patent. So geographical indications, this is there. And next we have the trade secrets. The trade secrets are defined like a formula, a pattern, a device, or set of information which gives you opportunity to have advantage over the competitors who don't know or use it. Examples of trade secrets are manufacturing processes, ingredients, chemical composition. So I would like to give a very appetizing example for this trade secret is, like we would have taken, or we would have went to lots of restaurants. So in when we go to certain restaurants like the Talapakati biryani or the A to B, so we can see that the taste is very particular to that place. So they have a secret, they have a formula for creating that dish, and that has been maintained, and that is the trade secret. Similarly, for the all the food products, they will have a trade secret. So trade secret is something which is a pattern or a formula or a set of combinations of composition which has been established by the particular company. They maintain it and they never let it out. So that is what called as a trade secret. For example, the ice cream composition of Amul, Arun, and Ibaco, Hudson, and all those things. So that is the process, and the manufacturing process is said to be called as a trade secret, which is maintained by the most of the food industry, and also certain mixtures which has been developed in combinations of materials. So that trade secret is again another area. Next we have so far we have seen the types of patents that can be claimed for based upon the idea or the logo or the design or the process or the agricultural product or the plant or breed. So all those things could be patented in different forms in India. Now we have the acts. So as I told you, I had individually mentioned this also, the legislations or the laws that are existing in India. We have the Patent Act 1970, Industrial Design Act, which is for the design patent, Trademarks Act for the trademarks, and Geographical Indications Act 1999. So all these laws are administered by the Office of the Controller General of Patents, Design and Trademarks. So here the agent, the government office which is controlling all the processes all of filing the patents and being taken care of filing the patents, screening the applications and giving a grant for the patent has been taken care of the Controller General of Patents, Design and Trademarks. And here this there are regional offices for these setup, and that has been overall monitored by the central government. And next we have the IP identification and management, startups and entrepreneurs. So if you are having an idea, you have to start a business with the idea, and you are going to patent your idea. What should be done and what not should be done is that is develop an IP strategy. Okay, so you should not stick on to, okay, I'm going to get only a patent, I'm not going to get a trademark, I'm not going to get a copyright. So don't stick on to one IP strategy. See that whether your idea could be patented. If you have a particular design, you do a design patent also. If you have certain logo design, that also you take a trademark, and all whatever thing you feel it should be protected, you develop a strategy for that. You patent all those which is innovative, which is being defined by you. So consider all forms of IP. It can be a geographical indication, it can be a patent, it can be a copyright, it can be a trademark, anything. So consider all forms of IP and choose which could be helpful to you for the patent and establishing your business. Conduct trademark availability. Check for the trademark availability. See if you have some logos, if you adopt to some logo, see if that is available in the market, or whether someone else is using that, and all those you will have to check on. And involve IP attorneys. IP attorneys are the legal persons who are going to file the patents for us. It can be done by us also. We can also approach an IP attorney, the legal persons, to file the patent. And also you can go for non-disclosure agreement at early stages of business. Suppose you alone, you're going to be the innovator, but your friends are going to become a partners of your industry or your business. So in that case, you need to tell your idea to the friends, but before patenting, you cannot tell your ideas to your friends, because there is a possibility of them taking it and producing it somewhere else. So take a non-disclosure agreement before patenting it or before early stages of business, and then you disclose the ideas with the partners alone who are going to get involved. Only after getting the NDA, you discuss with them. So don't skimp on your IP budget. So don't think that getting intellectual property rights is going to cost you a lot. So it is not at all. Very cheap, and the government is also giving lots of schemes and methods, strategies to reduce the cost of patenting. And there are lots of schemes which will help a startup to bear the cost also. So once if you get into the business, and the entire system will help you to get the IP at a minimum cost. Only the government charges, only the fees that you have to pay to the government is being charged in most of the cases. So file for a provisional patent application. Provisional patent application is something like you have not developed the entire model, but you have the idea. So with the idea, with the write-up and with the diagram, you can file a provisional patent, after which you can create the model, and then you can go for a complete specification patent. So initially you have an idea, and immediately if you want to protect it, you go for a provisional patent. So focus patent applications on a specific technology. So don't combine most of the combinations kind of thing. Have a specific technology which will help you the patent get the patent easily. So ignore competitors' patents. Don't go for searching the competitors' patent, and don't overlook the details. So don't keep saying that this component is already available and that component is already available. Whatever you feel innovative, you try and apply it for a patent. So that will help you, and it will also help you to identify what can be different in your idea. So who can file a patent is any inventor can file a patent. If I'm innovating an idea, I'm saying a new concept, I'm going to design a new concept, or some new laptop I'm going to design, and I'm going to patent it, I can do it. So I will be called as an inventor in this case. Inventors can be a single person, or it can be a group of person. Okay, so that is the inventor. Assignee is I will invent, and I can assign the person. If in case a startup, the startup is said to be called as an assignee. Startup in the sense, you will have a group of people, they will be assigned to get the patent for their company. So for the company, if you want to take the patent, then there you become an assignee. And if you are working in an institution, if the students and faculty together are working in an institution, and if they are trying to get a patent for their innovative idea, both the student and the faculty together, from the institution, they will be called as an assignee. Here nobody is the owner. Institution, the student and the faculty together, they will be assigned to own the patent with some legal rights. So that is also they called as an assignee. So the next thing is legal representatives of any deceased person. In case if a person is not available, he is not no more, then the assignee, the legal representative of that deceased person can file a patent for that particular idea. So who can file a patent is here, like inventor, assignee, and the legal representatives. Here, while applying for the patent, it will be asking for who is the applicant and who are the inventors. Applicant is a person who will apply for the patent. So the applicant can be the inventor itself, or the applicant can be a person or a legal person who is filing the patent for the inventors. So under the inventor category, the person who is inventing the concept have to come into picture. So applicant can be either the same person, or it can be an external person who is filing the patent for the inventors. Okay, so here where to file a patent, you can see that in India we have all Indian residents can file the patents at the head office at this branches, and northern states we have Delhi, and in the western parts we have Mumbai, and the south we have Chennai. Other than these areas, it is Kolkata. The head office is at Kolkata. So these places we have the patent office, and from there we can directly go and we can file a patent, wherein we should know all the processes. First sitting, we should know the process, and then take over the documents, go to the office and file a patent. And there is also another option like e-filing of patents, which has been done on the online. It can be done either by the inventor, or it can be done through the attorneys. Attorneys are the persons like the lawyers or whoever are experts in filing a patent. You can go to them and you can make it file a patent through the e-filing system from the attorneys. So that is also possible. So these are the places where we can file a patent. Then coming to the actual process of filing a patent. So first thing is, there are two types, as I told you, provisional specification and complete specification. So provisional is immediately you have an idea, you see that the novelty of the idea is very high and immediately it could be adopted by someone else. So you want just only the concept to be filed with the written format. So you go for the provisional specification. So that is the first thing. Without provisional specification, directly you can go for the complete specification, wherein you have the entire write-up with the objectives, the claim and all those things with the model of the design, everything is ready, and then you file the complete specification. So once you go for the provisional specification, after provisional specification, immediately you will have to go for the complete specification. And directly if you go for complete specification, after 18 months your application will be published, your patent will be published, your idea will be published after 18 months. So if it is rejected, and in that place itself, it will be rejected. So once after 18 months, if your patent is published, then you will go for request for examination. You will have to apply, you have to appear for examinations at the patent office. They will see your patent and they will ask you questions, or they will get you reasons for the innovations what you have made in your patent. So you have to, after the patent has been published, you will have to request for examinations. After the filing for examinations, you will have to appear before the patent office for the hearing. What they will say is, you will have to give your claims. They will ask you questions, and there you will have, if the panel is being satisfied, they will order the grant. If not, the patent will be refused. So when the exam request for, after the exam request for examination, you will be given an examination fees, and you will pay the exam and you will appear for the exam. And after the exam, first examination report will be created based on your answers for the idea. A first examination report will be created, and that report will be submitted to the hearing, that is the IP office personnel, and they will be looking at the details of the patent through the first examination report, and they will call you if further more doubts and clarifications are there. And after that hearing, immediately you will get with an order for the grant. If it is a success, you will get the order for the grant, and we can say that the patent is granted. So after the approval of the hearing, the patent is said to be called as a granted, and the patent number will be allotted to your idea. So that is the process, end of the success of the process. And if the hearing, the IP office is not satisfied with the answers we have given during the hearing, the patent might have a chance to get rejected. And within 3 months, if you want to appeal, that means you say that this is an innovative idea and I'll come up with the say perfect solution of claiming this again. Within 3 months, you can go for appeal against the order, to again the same process will be starting. Okay, so this is the entire filing process involved in filing the patent. And it looks so complicated, but actually it is very simple, because when we try to filing the first patent by us itself will be difficult, but later the second, third, we'll pick up the speed and it will be going on. So we have done lots of process in this, and we have also learned more steps in this, right? So next we have the forms for filling a patent. So here the forms for filling a patent is this, you can get it from the e-filing process on the website. So there are various forms. So one is the first form is the application for grant of patent, wherein we will give the basic details on the applicant, inventors details, and all the specifications will be asked in that. And second, we have the provisional or the complete specification. This will be filed within 12 months for filing the provisional. The complete specification should be filed within 12 months of filing the provisional specification. So that is thing. And the third step is statement of undertaking for foreign application. If in case, if we want to take it to the international level for filing the patents at the international patent office, then we have to take that. If not, that can be eliminated from the process. Then declaration of inventorship. We need to, with the complete specification, we have to take the acceptance and the signatures of all the inventors. If there are 4 or 5 inventors, up to 10 inventors we can have. So if there are inventors, we have to take their declaration and we have to get their sign and we have to submit it. That is also needed, mandatory process. And then next is, once it has been published, within 18 months, we'll know whether it is published or not. After the publication, we'll have to request for the examination. So we'll request for the examination, and then we will also be called for examination date, and we will go for the hearing, after which you will have to assign an attorney to go for the hearing. So when we go for the hearing, we have to authorize a patent agent. We need a legal formality and we need a legal support. So we go to an attorney or an authorized patent officer. So he will help us in writing the claim and going for the patent grant. So that will be the process. And after, with his support, with the attorney's support, we will be going for the hearing, and then whatever it is being granted by the patent office, we'll be taking forward. So these are the steps, main steps, and the main forms which we need to file for a patent. And if the process itself says that for the publication of the patent itself, it takes 18 months. What if is there any short method wherein the publication can be done early? If that is the question, then answer is yes. We have to file the form 9 if we want an early publication. So form 9 is for requesting for early publication. Within a month, you will get the publication, and immediately after the publication is received, you can go for the request for examination. So we need not wait 18 months. So nowadays, e-filing is done for the complete specification, and immediately within a month, the publication is also received by submitting the form 9. So no other form 30 is to mention that whether no other form is prescribed. So anything else, if it is required, then you can see the e-filing procedures on the website. These are the main forms which needs to be taken care and submitted during the filing of a patent. And now the process is being done, and what could be patented we have seen, and what could be not patented is mere discovery of scientific principle cannot be patented, rearrangement of known devices, agricultural methods, plants and animals treatment, mathematical or business methods, and invention against natural laws. All those cannot be patented in India, and anything which is related to atomic energy also could not be patented, and we cannot claim for anything on that. So these all cannot be patented in India. And this is the entire setup of IP, and taking forward, the challenges are like India needs to strengthen the ecosystem for innovators, and we have to ideate. Students and faculty have to think on more innovations, more ideas which will solve certain problems, and apply for patents and start a business. And so that is the need of the hour. And we at IIC, all innovation ambassadors and all faculty members, all academicians are striving together to make students more innovative and also start their own business in the future. So trust me guys, entrepreneurship is one area where students are going to have a lot of potential, and there are lots of scope in entrepreneurship in our country. So go for innovating things, go for finding out new ideas and applying it for the betterment of the society. So that is what India wants in the future. Break your own records, ideate, innovate, Make in India, make India proud. So whatever we design in India is going to make India proud. So best wishes and thank you. If any doubts on IP process and other things, you can Gayatri ma'am has my number and I'll share my email ID also. If you have any doubts or if you want to file a patent, you can get in touch with me. I'll be always there to help you. Thank you. And if any doubts, you can ask. Students? Any doubts?
No, ma'am.
Okay. Hope the ideas were clear.
Students, kindly raise your questions. If you have any doubts, kindly ask them.
Has anybody tried to take a patent, students? Okay. So think on, it's too early for all of you, but you can think on ideas in your domain, in your field, whatever you study or something which is which can be converted into a business. So think on ideas, go for patents, and keep thinking and developing your knowledge on innovations, on new things. So that is very important. And thank you all, ma'am. I think no doubts.
Ma'am, I have a question.
Yes, ma'am.
Ma'am, when we are applying for the patent, after getting the patent, shall we publish the patent content as a paper?
Yes, ma'am. Sure, we can do that. So once you get the patent, you can publish it as a paper, but you have to mention in the acknowledgement that this has been patented under this number, and all those things have to be mentioned in the paper. Get it, ma'am? You get it? Did you get
Yes,
it?
ma'am. Yes, ma'am. Yes, ma'am. I got it. Ma'am, when the students are going for the patent, should
Yes,
they
ma'am.
go to by the name of the college, or we can go by the SL?
Ma'am, it is again, it depends upon the national innovation and startup policy you have at the institution level. So if your policy says, if your innovation and startup policy says students have to go only through the college, then the applicant will be college and the inventor will be student. It depends upon the terms and conditions you had framed it in your policy, innovation and startup policy.
Okay, ma'am. Thank you, ma'am. Thank you so much. Very informative session, ma'am.
Thank you, ma'am. Thank you.
Thank you so much, ma'am, for sharing your informative views with us. Nothing is greater than gratitude. The root of all goodness lies in the soil of appreciation. Will I able to thank you enough with my words? I wonder. But I do want to thank you all from the bottom of my heart. First and foremost, I like to thank our honorable correspondent, Thiru K. Palanisamy sir, and our principal, Dr. Raman sir, for providing their immense support to make the workshop successful. I like to extend my gratitude to our honorable resource person, Kavita Karthikeyan ma'am, associate professor and head, assurance cell, innovation ambassador, institution innovation council, Prince Sri Venkateshwara Padmavati Engineering College, Chennai, to take a time from her busy schedule to grace the event. It was really great time with you, ma'am. Thank you for sharing your informative session with us. My heartfelt thanks to IAC President Dr. J. Gayatri Ma'am, Associate Professor, Department of PG Computer Science, Vice President Dr. V.G. Sumati Ma'am, Head of the Department, Management Science, and all our faculty members for their support. Last but not least, I like to thank our IAC student coordinators and student participants for their support. Thank you.
Ma'am.
Yeah, thank you, ma'am. Thank you so much. Thank you, students.
Thank you, ma'am.
All the best. All the best. Thank you, ma'am.
Thank you, ma'am. Thank you. Students and coordinators, thank you. Can leave the meeting.
Thank you, ma'am.
Feedback link is there on the chat box. Kindly give your feedbacks and then you can leave the link.